All right, good morning, folks. Law fam, Soul Tribe, whoever's here. I've had a day or a little over a day here to process this whole trial and what happened and what went down. And I thought I'd get on here and try to explain it to people that ain't quite getting it. So I'm going to read what Catherine Wilking, the judge, executive administrator, did, and kind of go through some things here to try to explain to people that apparently can't read between the lines. So what I'm going to do is I'm going to read this whole thing, and then I'm going to kind of touch on some points here, try to help folks out. All right. Order following bench trial. The above captioned matter came before the court for a bench trial on July 10th, 2023. The state of Wyoming was represented by Samuel Forshner and Blaine Nelson, and the defendant, Frank Barris, appeared pro se, having refused appointment of counsel. The court, having reviewed the evidence presented by the parties at trial, having heard the arguments of Mr. Forshner and Mr. Barris, having fully reviewed the applicable law, and being otherwise fully advised in the premises, fines, and orders as follows. The defendant's position. Mr. Barris submitted several filings to this court, as well as Natrona County Clerk's office. His intentions are without merit, and his theories and positions are not established law in this court or anywhere in this country's valid legal system. Mr. Barris identifies himself as a state national and has consistently and passionately argued that the actions of the law enforcement officers, the district attorney's office, in this court did not apply to him because of his self-proclaimed status. His passion for his beliefs does not make them a reality. Mr. Barris, like all individuals in the United States, is subject to the laws of the jurisdiction in which he resides, and his purported status as state national does not enable him to violate those laws without consequence. The law applicable to this case. This court findings, which although ultimately land in the favor of Mr. Barris, are in no way based upon his arguments, beliefs, or positions. Rather, they are solely based on the constitutions of the United States of America. Notice that was plural, but anyway, and the state of Wyoming, as well as the Wyoming rules of evidence, the Wyoming rules of criminal procedure, and the statutes of the state of Wyoming. The charges filed by the state of Wyoming. The state of Wyoming charged the defendant by an information filed November 23rd. This incident happened on November 9th. Count one of the information alleged that on or about the 9th day of November, the defendant unlawfully possessed a deadly weapon with intent to unlawfully threaten the life or physical well-being of another in violation of Wyoming statute, section 6-8103. Count two of the information alleged that on or about the 9th day of November, the defendant did lawfully drive a motor vehicle on any public highway when his driver's license was suspended in violation of Wyoming statute, section 37-7-134C. The burden of proof. The burden was on the state of Wyoming to prove each and every element of each offense to the court as the trier of fact behind a reasonable doubt. The law raises no presumption against Mr. Barris, and the presumption of law is in favor of his innocence. The presumption of innocence continues with Mr. Barris through all stages of the trial and until the court finds that the presumption has been overcome by the evidence in the case, convincing the court of his guilt beyond a reasonable doubt as to each charge offense. If the court has a reasonable doubt on any necessary element, the law requires that the benefit of such doubt be given to the defendant, and the court must acquit him. The evidence proven. The state of Wyoming established that the alleged offenses occurred on November 9th in Natrona. The state of Wyoming established the identity of Mr. Barris. The state of Wyoming established that Mr. Barris's driver's license was suspended and that he was in possession of a firearm in a holster located on his hip. The insufficient evidence. It appears to the court that the substantial evidence was available to the state of Wyoming to establish each and every element of the offenses charged, but it was not presented through exhibits or the testimony of the state's witnesses. The reasons for this are unknown. The state of Wyoming failed to present evidence that the defendant was driving a motor vehicle and that he did so on a public highway. The evidence before the court establishes The evidence before the court establishes that Mr. Barris was in the driver's seat of a stopped motor vehicle on November 9th, 2022. The state did not present evidence to establish that he was driving. The court was not provided with video evidence of him driving, and the state's witnesses did not testify that they saw him driving. Trooper Bryant reportedly made the initial stop, but he was not called as a witness. Trooper Cross did not testify about being informed by Trooper Bryant that the defendant was driving, nor did he testify that he had received reports or videos that would demonstrate the defendant was driving. Trooper Cross testified that Mr. Barris was stopped on US 2026 at mile marker 26. The state asked Trooper Cross if that location was in Natrona County, but did not ask the trooper or any other witnesses if it was a public highway. The state failed to provide sufficient evidence to establish the defendant's intent to unlawfully threaten the life or physical well-being of another. The state did not present sufficient evidence as to the reason for the initial stop. Again, Trooper Bryant was not called as a witness, and Trooper Cross was not asked questions about the initial stop. When Exhibit 100 was played, the court heard the defendant tell the Corporal Christensen with the sheriff's office that he was apparently speeding. The court was not provided with any video evidence or testimony from Trooper Cross or Trooper Bryant about the reasons for the initial stop. In fact, Exhibit 100 shows Trooper Bryant telling defendant, "I never said you were getting a ticket." Trooper Cross was not asked how he learned about the defendant's license suspension, and the state did not present evidence to establish when Trooper Cross learned of the suspension. Trooper Cross was not asked how he learned of the warrants introduced as Exhibits 200 and 201. Trooper Cross was not asked when he learned of the warrants or how he or others determined the warrants were valid. Trooper Cross testified on cross-examination that perhaps Trooper Bryant ran the defendant's name through NCIC and the warrants were reported. This is speculative. The state did not elicit testimony from Trooper Cross about what Trooper Bryant may have told him during the stop about the existence of warrants. The state did not elicit testimony from Trooper Cross as to the standard practices of Wyoming Highway Patrol officers during traffic stops relating to NCIC and warrant checks. The state of Wyoming did not present evidence to explain why Trooper Cross and Trooper Bryant did not inform Corporal Christensen about the existence of warrants. Corporal Christensen testified on cross-examination that warrants were not mentioned while he was there, and he didn't know what the discussions were before he arrived. The brief synopsis of the video from Corporal Christensen's body cam highlights additional areas where the court finds the evidence insufficient. The video begins with Corporal Christensen approaching the passenger side of the defendant's vehicle. The defendant is arguing in the general direction of Trooper Bryant and Trooper Cross and begins to argue with Corporal Christensen. The defendant loudly proclaims through the interaction that the officers do not have any authority to stop him, to detain him, to keep his passport, or to require him to exit his vehicle. Trooper Bryant is seen telling the defendant that he never said you were getting a ticket. Exhibit 100 is approximately 33 minutes long. Throughout the video, the officers are polite, respectful, and appropriate toward the defendant. Except when they threaten and break your private property, The video shows Corporal Christensen conferring with Trooper Cross from 1955 to 2130. Corporal Christensen is seen turning the audio portion of his body cam off, so only the video is shown. When asked on cross-examination why he turned off the audio, he explained that he turned the audio recording off because they may have been discussing law enforcement tactics and did not want those divulged. Because public servants should have tactics for their masters, right? Be that as it may, the court was not provided with any non-tactic testimony to explain the substance of the conversation between Corporal Christensen and Trooper Cross as it related to the defendant. After Corporal Christensen and Trooper Cross confer, Trooper Cross is seen approaching the defendant and telling him that they have no driver's license, speeding, and no plates, and the defendant needs to exit the vehicle. Trooper Cross then goes through the three options with the defendant, that he will ask him to exit the vehicle, tell him to exit the vehicle, and then break the window and remove him from the vehicle. This is the first time the defendant is advised of the alleged minor traffic violations, speeding, no driver's license, and no plates. The defendant is never advised he has warrants for his arrest. Corporal Christensen is never advised that the defendant has warrants for his arrest. Trooper Cross testified that he was not required to advise the defendant about warrants for his arrest. It is unclear why Corporal Christensen was never told about the warrants. It's because they didn't exist. The defendant repeatedly asked why he needs to exit the vehicle and mentions that he fears being kidnapped by the officers. The officers never explain why they are asking him to exit the vehicle for the alleged traffic offenses. The defendant responds at 22-46 on the video, tells Trooper Cross that if they remove him against his will, it is going to go south. At 23:51 on the video, the defendant tells Trooper Cross if they remove him by force, they will have a gunfight on the side of the road. During this exchange, all the officers are unaware of any weapon in the vehicle. Right. Both Trooper Cross and Corporal Christensen testified that they never saw a gun. The defendant alleges was by the center console of the vehicle. After the defendant makes the statements, Trooper Cross and Trooper Bryant leave the passenger side of the car, and Corporal Christensen talks to the defendant again on the video at 25:50. Corporal Christensen asked the defendant why he is saying they will have a gun sight on the side of the road, and the defendant responds with his explanation for making the statement. Corporal Christensen testified that during his explanation, the defendant lifts his shirt and briefly shows him a holstered weapon on his hip, and then the defendant lowers his shirt. At 26:15 on the video, while he has stepped away from the vehicle, Corporal Christensen tells Trooper Cross that the defendant has a gun on his hip. Corporal Christensen testified that he understood the defendant's action in lifting his shirt was to let him know the gun was there. He was concerned by it, noted it, and wanted both troopers to know it was there as well in case something happened while he was engaged with the defendant. Corporal Christensen then tells the defendant that they are going to go make some calls. The video was stopped at this point during the trial. Yeah, because the DA only played 21 out of 33 minutes, if I remember correctly. After Corporal Christensen and the trooper Cross leave the passenger side of the car, and right before Corporal Christensen turns off the audio on his body cam, again, either he or Trooper Cross say, it might be better to let him go and write warrants. The audio is turned off from 27:26 until 32:42. The court was not provided with any testimony about the conversation between the officers during this time, or what calls, if any, were made. The court was not provided evidence regarding any discussions about the gun, the defendant's statements about it going south, or there being a gunfight on the side of the road, or how those things impacted their decision making. The court was not provided evidence about what the officers planned to do about the existing warrants that didn't exist. The court was not provided with an explanation for why they would not arrest a defendant on valid warrants signed by a municipal court judge and a circuit court judge. The audio is turned back on at 32:44, and Trooper Cross is seen handing the defendant his passport and saying, "You are free to go for now." The video ends at 33:24. The law raises no presumption against the defendant, but rather the presumption of law is in his favor of his innocence. If the court has a reasonable doubt on any necessary element, it is required to give the benefit of such doubt to the defendant and acquit him. The court must be governed solely by the evidence and cannot indulge in conjecture or speculation unsupported by the evidence. While reasonable inferences and conclusions can be drawn from the evidence, there is a limit to such inferences, and it is improper for the court, as the fact finder, to use those inferences to make up for the shortcomings in evidence presented by the state. The state has failed to meet its burden of proof on count 1 and count 2. The court finds the defendant not guilty on count 1 and count 2. It is hereby ordered that any bond posted herein is discharged and exonerated. Okay. So that was the ruling. Now, she read this and she had a, here's the thing with this Catherine E. Wilking. Ever since the first court appearance I showed up at, I felt like this woman was actually listening to me. And you don't usually get that in the courts. I mean, these people are so damn indoctrinated, it is pathetic. And she always gave me the chance to talk. And I found that, I guess, I don't know, it's just weird, because they never want to let you talk when you're in their dry dock ships, right? So she gave me every opportunity to talk and explain and tell my side of the story since the beginning. I have to take my hat off, tip my hat to this woman. I mean, literally, when they threw me in the cage for not committing a crime for 3 days and then drug me in behind the bar, they had Patchen, which me and this guy's crossed paths before, and he was the one at the initial, when they brought me in my orange suit still. And so at that point, when you bring me in behind the bar, it's liar's court, because that's court rules anyway. That's, whatever. So what's funny about this is the judge I know that don't like me, and me and him don't like each other, was taken off the case. And then this Catherine E. Wilking was brought in, and I was actually being listened to and allowed to talk until I was out of breath or got my, and that just never happens in a court. Okay. So there was something about this woman that told me that she was living out of her heart, not out of her ego, but it was hard for me to be honest, it was hard for me to trust her, even though my heart was telling me she was listening. My brain and my ego or whatever, it's like she's still, she still works for these corporations. She's still, going to cover for her people. And I just couldn't bring myself to fully trust her. And I, told a buddy of mine after the trial, I said, if she's fooling me, she's good. I said, because my feelers usually ain't never wrong about people, and so pretty much what it boiled down to is my heart was right, that she was there to literally help me. I mean, I don't know how to explain it other than an angel sent from the gods, to replace Patchen, which is a jackwagon. And then I get her, and then she's allowing me to speak my piece every time I go in there. And I turned in so much of my paperwork, my legal notice and demands, my assertory oath of repudiation of citizenship. And she read all this. I truly believe this woman read all this. I think she's seen the chicanery that was going on here. And what I had done is provided enough evidence to her that, the U.S. Supreme Court has for 100 years said that you don't need a driver license to travel unless you're dealing in commerce. Okay. I proved that I've taken myself out of their corporations. I don't need a driver license. My political status and standing has changed. I even told her in one court setting that I was a bad alcoholic drunk for 24 years, and the socialist state of Illinois had convicted me of being a felon, ma'am, for the same things I'm doing here, not committing a crime. I said, and then I go and do all this paperwork, especially the David Straight paperwork. And like 2 months after that, I'm absolutely invisible. 6 months after that, I'm crossing international borders. I says, ma'am, convicted felons with the driving records I had don't cross international borders. I said, so how do you explain how, this court don't accept any of my paperwork, yet I can cross an international border because my record has been expunged and cleaned because of my status and standing politically. Okay. And then during this whole case, the state, or not the state, but the DA's office, the state, I guess, whatever, ain't my state. These District of Columbia attorneys were standing on that I had warrants for my arrest. But it's like I told Catherine, the executive administrator is what she actually is, that, and it even says it right here, blah, blah, blah. The state charged the defendant by an information filed on November 23rd. Huh. So what's that, 2 weeks after the incident? Now all of a sudden they finally get their lies and their bullshit together to write warrants on me? Like cops just go write warrants. Like that's even part of the law, okay? A cop getting a warrant ain't no different than you or I getting a warrant. You got to go in, fill out an affidavit. It has to be brought before a judge. The judge has to see that there's probable cause and a crime has actually been committed before they can even issue a lawful warrant on anyone, okay? So when she caught them boys on the video saying, we'll just let him go and go make warrants, she knows that's bullshit, right? So here's what I've been processing. My whole defense against this bullshit was they were telling me I had warrants for my arrest, and me and my people, the people that watched my critters when I went over to Canada border and was gone for 10 days, they're, the daughters of this man that helps me, buddies, we all keep up with this stuff. We're always looking on there. So we had, I don't know, like 3 screenshots we had printed, one from Steve's phone and 2 from mine. And I had all 7 witnesses swear under oath that they knew that I went to Canada, and like 4 of them had actually looked it up on their phones, and we admitted all that into evidence. And I was cross-examining the circuit clerk, and I asked her, "You remember me, ma'am? I was in there early this year with 3 fraudulent contracts from your policy officers in Mills." And I said, "I did a 72-hour right to rescission on those tickets, and you immediately faxed them to the judge, correct?" And she said, "Yes." And I says, "So where did all that go, ma'am?" I said, "Why didn't I ever have to show up for court on March 7th? Why were there no warrants ever issued for me?" And she's like, "Oh, I don't know. It just kind of disappeared." I was like, "Yeah, because I actually know the law. And you as a circuit clerk are supposed to be the most highest authority of the law. You're literally stamping these documents. You're supposed to know more about the law than anyone in the county. Now, where'd you study the law, ma'am?" "Well, I don't." I was like, "So you're just appointed corporate employee like the rest of them. You actually have no background in studying the law. So how do you justify being a circuit clerk, right?" So I'm going at these guys, proving that the chicanery, that they went back 2 weeks after the incident and started creating or writing warrants that didn't exist because everything had already been cease and desisted 2 years prior. But these DAs were standing on that these warrants had been out since like February of 21 or something like that, and it wasn't the case. So we came in there and literally proved that these guys, these egotistical cops, were running on pure ego, and there was no warrants on me. Okay. And then, like I said, with all the other evidence I presented to her, and then I read some things, before the trial. I was like, had my opening statement and whatever. And I asked her, I was like, "Miss Wilking, are you administering my trust without my consent?" So I give them all the opportunities because they knew, okay? And she knew once she read my paperwork that I was absolutely correct with my political status and standing and what I was saying. Now, this gal can't admit that, all of that, because she's going to, it's gigs up, right? The scam's over, lose her job or livelihood or whatever. Now, what I do have to say about this woman, and this is the part that got me, it just threw me. When she come out and started reading this, and it says how, Mr. Barris's beliefs and all this or whatever, I thought, here we go. We're getting railroaded, and I'm already thinking appeals and writ of habeas corpus and orange jumpsuits and the whole 9 yards. And then all of a sudden she starts bringing up that the state had never proven that I was even driving that day. And I was like, she's literally fighting for me. Okay. So this woman, you guys, this angel from the gods needs to be recognized and respected. And she needs credit for what she did, because she literally did the right thing, but couldn't admit that all my papers and all my status and standing is lawful or legal, because it all depends which jurisdiction it's in. Because then that proves the scam that they're living under in these dry dock ship courthouses, these corporate courthouses. So for her to come out and literally go in defense of me, which I had never thought about, not once, that nobody proved that I was even driving that day. Okay. Just goes to show me that this woman was seriously working through her heart and she wanted to see justice done. And she did it the only way that she knew how. And I respect the hell out of this woman for that. I mean, unbelievably respect the hell out of her for this. And then turns, and then finds me not guilty and exonerates all bonds. How is it? Hereby ordered that any bond posted herein is discharged and exonerated. Well, that's where warrants start with a bid bond. Okay. So there was no valid warrant. She knew there was no valid warrants. I'd proved this chicanery and this bullshit the whole time. But like I said, the difference between this woman and most of these executive administrators is she was not just hearing me, she was listening. And she was listening with her heart and not her ego. And apparently because I come from the heart, and she even said passionately, whatever, Mr. Bears passionately explained his position, because that's how I live, is out of my heart. I don't try to be in my ego, because that don't get nowhere. You got to listen to your heart and listen to your soul and live that way. Stay out of the ego and everything works out. This is a prime example. I stayed in my heart the whole time. I didn't try to play these liar bullshit games. These lawyers, these people are just, I don't want anything to do with that energy. I don't want anything to do with that verbiage. I mean, it's all just lies and it's fake. Okay. It's their fake world they live in and how they justify their existence. Right. So the point is here, I want all the patriots that are in a movement like this to understand that when I came in there, I just came in there telling the truth, you guys, and I was standing and speaking on my truth. And, the DA first, they come at me with, mental incapability or mentally not fit or something like that. I was like, really? I was like, that's cute, because I showed up here with a duly authenticated birth certificate that is bonded for $100 million, perfected the law the very first time I got here. And these bar attorneys don't know what to do with it. And the reason is, ma'am, is because they're still practicing law. They don't perfect law. I mean, don't anybody find these words funny? How can you be a goddamn lawyer for 30 years and you're still practicing? You haven't got nothing right yet. You're still practicing, right? You ain't even made it to the big game if you're still practicing. It's hilarious, but nobody knows what words mean, or nobody thinks about what words mean. So anyways, I've been trying to process this for the last day and a half, because I'll be honest, I was actually shocked. I thought for sure I was getting railroaded and it was all going to go south. And then this executive administrator pops up out of nowhere, this literal angel that God sent down here, and literally comes out and helps me fight my case from an aspect and a side of things that I didn't see or even think of, or nobody behind me, all my guys, all my people behind me never thought of. That woman needs respect, and she needs to be recognized for what she did, because she might have put the nail in her coffin of her career doing this, and I just hope and pray that these damn nasty we all know who runs this shit, don't come after this woman, because she did the most righteous thing. She literally upheld the law, but she couldn't and didn't tell the truth about it, because otherwise the gig is up, right? They'll disrobe her if she come out there and said, yeah, this guy's taking back his political status. They never had the whole gig is up then. I mean, if that would come out like that, these patriot this shit would be over in a couple months. So they're still trying to hang on to what little bit of the power and authority they got. But for this woman to come out and do what she did, you guys, to me, hats off. She deserves all the praise and all the flowers you guys want to send her. Her name's Catherine E. Wilking. And this woman deserves gifts and praise from every one of us patriots, because this woman did the right thing, even though it's not written down exactly like what happened. But so I just wanted to kind of touch base with a lot of the people, because you got these minions on here, and I'm sorry, some of you guys text, I get these texts and it's, it aggravates me sometimes. I ain't got time for stupid. Okay. I hardly got, be honest with you, I'm so damn busy. I ain't got time for people with open minds, with questions, with all this shit going on. But I feel compelled to help people because I've been there. Okay. I've been going, what the hell? How the hell? What am I supposed to be? I'm chattel, right? Sesta KV Trust from the Act of 1666. What? Until you understand who and what you actually are, and until you stand up and have a backbone and express your God-given unalienable rights of who you are, nothing's going to change, okay? And that's why I was saying the other day, all this paperwork I've done, absolutely ludicrous amounts of paperwork and money I've spent on all this paperwork to take myself out. And I honestly believe, you guys, it is more important to stand up by stepping into your spiritual sovereignty. And when you run across these agents of foreign corporations, policy officers, whatever you want to call them, that have no authority over us unless you consent to it, okay? And that's all we've ever done is kowtow and consent to an authority that don't even exist because of our ignorance and the brainwashing, okay? Until you stand up, and this is my new thing. I just came up with this a couple of days ago, but it makes sense to me. Until people stand up and they say no. How is that even viable? Can you show me or produce a law, not a statute or a code, but an actual law of this land that is viable? And when they say blah, 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 say, well, it sounds like to me you're ignorant about the law, so I'm going to ask you politely to get out of my way. Otherwise, I'm going to use my Second Amendment for you violating my First. And that'll be the end of it, okay? That's all people need to do is stand up. And another thing I told a bunch of fellers, I says, when I was talking about all this, they're like, well, I don't know how you retain all that. And I don't know how you, all this and that. I said, look, it ain't that hard, you guys. You either understand the Bill of Rights or the Ten Commandments. It's not rocket science, okay? That's all you got to do. Understand those two documents or whatever those, and stand up, okay? It's about standing up. And what the standing up does that most people don't realize is it changes the vibrational consciousness level of the collective consciousness. And once this level gets high enough, this gig is over, okay? It just takes people with a backbone. The problem is we live in a country of a bunch of sheeple with herd mentality that are more concerned and more worried about what their damn neighbor's going to think about them, or their buddy at the tavern pouring poison down their neck on a bar stool thinks about them, than they even care about their own well-being and their own rights and their own children's rights. I mean, it's like I told her, I said, ma'am, all I did was stand up for my right to travel freely down a public thoroughfare, which is backed up by 100 years of Supreme Court case law, which I realize is not law. It's just a judge's opinion. But here's the facts. I said, and then when these three highwaymen, these pirates, these road pirates tried to break my private property, I stood up and said, no. If you break my private property, we're going to have a gunfight. And it's that simple. Okay. I was, and I am still literally willing to die for the rights that are God-given and unalienable that these corporate policy officers are trying to take from us. Now, until you got the nutsack to stand up and do that, I don't want to hear no bitching or complaining or whining from you people, because you're not standing in your spiritual sovereignty and doing something about it, okay? And that's what needs to happen, guys. But I just had to get on here and give Catherine some praise, because this woman, seriously, you guys, how many times have you ever heard of something like this? This don't happen in the United States courts, right? Because we ain't had a real court. Hell, we ain't had a real judge in this country since 1879, okay? That's when the last real judge died. All of these have been our corporate Congress executive administrators. That's why I tell people, when you take back your natural birthrights through David Straight's paperwork with the Asturi Oath of Repudiation, you literally change your political status and your standing, okay? And what that means is every bullshit corporate bylaw that they passed with a corporate Congress, since they whacked Lincoln and the two foreign corporations of the territorial and the municipal, usurped our country, swept our organic constitution under the rug and brought in their two corporate constitutions for us to live under, then created the 14th Amendment U.S. citizen, which has no rights, only has a lot of privileges and immunities, okay? Not one of these laws that I think April or whatever, some 1863, don't apply to us. They're corporate bylaws that only apply to the 14th Amendment U.S. citizen that they created to go along with the Act of 1871. This is not rocket science, people. It don't take that long to cipher this information and understand it. If I can do this, okay, anyone can do this. I am no rocket science, okay? I'm just a country boy that has been brought up in a world that never made any sense to me, okay? I've had eyes and perception like most people don't, and I stood on it. Like I said, I figured it out after I got laid off from the scamdemic. You know, not going into town every day, absorbing negative energy from a bunch of damn minions. You know, it even cleared my head up a little bit more, and it's like, all you have ever done, bud, is listen to your soul. And you literally got convicted as a felon in the socialist state of Illinois because of that. You know, how pathetic of a species are we to allow this to happen and then allow it to happen to your children? Or better yet, you're so indoctrinated, you actually fight for the deep state in the military and go over there and kill women and children so they can prop up another dictator and steal natural resources. I mean, but then again, why does the military teach everyone how to drink so well? Right? Both my parents were Marines, both alcoholics. Because once they realized, like my dad, after 2 tours in Nam, that he killed all them women and children for nothing but a political war to prop up a dictator and steal natural resources, which means children, okay? How did he deal with that? Just like the military teaches you. Same way I was taught as a boy. Work like a man, get to drink beer like a man, blah, 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 macho this, macho that. Seriously, folks, I was 15 years old, bellied up to the bar and the tavern I grew up in, and thought I'd made it to the pinnacle of society because I'm drinking beer with the old timers. But when I got sober in 2008, I played the tape back, and that was the beginning of the end, okay? You cannot pour poisons down your damn neck poison your central nervous system and your body and your soul with spirits, okay? And they ain't the good spirits, right? And expect to come up with cognitive decisions. So with all that said, this mainly is to try to explain to the people how to read between the lines of this order that she did and how she went about it, so she literally wouldn't get her, neck in a noose or disrobed or whatever, And the thing is, this ruling has really helped because it's given me some more teeth, because now these corporate pukes can't hide behind the 11th Amendment no more. Now, when I go in and get the FOIA requests and the FORA requests and all this stuff, I'll actually get the same information that the bar attorneys get, because those ain't the same informations. You go in as a U.S. citizen for a FOIA request, Freedom of Information Act, you're not going to get the same documents as a bar attorney or a judge gets. Now, does that sound like justice? Does that sound like you live in a free country? Huh? No, it don't. But you got to have the balls to stand up and do something about it, folks. And we're getting close here. This thing is getting close. The more people that stand up, assert their natural, God-given, unalienable rights, the faster this is going to be all over. So with that said, love and respect to everyone. Have a good day. Peace.